maybe you can narrow the issues pretty quickly if the parties do get together. You need you need an umpire. The umpire could be this barrister or someone that can assist.
Yeah, but as I say, historically, a lot of lawyers are reluctant to enter into any negotiations early on. There's various reasons for that. Yeah. But that's all we've got time for in this segment. We've got to take a break for our sponsors. We'll be back to wrap up the show after the break.
Thank you.
Welcome back to the PI show. Before the break we were talking about mediations, alternate dispute resolution. There's a lot of things that go into successful mediations, but one thing I sort of should highlight is that the parties come together in good faith.
Correct.
So
we've had compromise,
and the parties are willing to compromise
and have an open mind.
An open mind?
Correct.
And no matter how many times you set up mediations and have alternate dispute resolutions, if one party isn't genuine about coming along with an open mind, then the mediation will fail. And, you know, the last resort's the court.
One of the great assets of a mediation is the ability to listen. Normally you get paper on a file, the insurer gets paper on a file, they read a file. But until they hear the other side present their case with and answer questions about the case and discuss it and discuss the issues and the problems.
And it's face-to-face?
That is. So it's an opportunity to have good faith discussions, to look at the issues and resolve the problems. That is totally different to the traditional Victorian adversarial model. Adversarial meaning you go to court and you fight. That you have barristers in there. That doesn't necessarily resolve disputes. The aim of the government with its dispute resolution policy, the overriding policy, is to try and get away from those systems and to have the parties come together early on and do what we've just outlined here tonight, to have a cost-effective discussion in good faith with open minds with an attempt to resolve the matter.
But take the scenario of multiple defendants. Say there's 3 or 4 or 5 people who the plaintiff says are at fault. So
that's a challenge, and that's in fact outlined again.
How do you deal with
a real challenge? Why is that a real challenge? Because it can be influenced by well-resourced defendants, a number of insurers who may have little interest in speedy resolution of the case, and a culture of adversarial litigation. Now, that's a real challenge to get a mediation to successfully work. Sometimes you have to get all those defendants in a room and you have to get them to agree to a possible solution and their contribution, because one might be in for 20%, one might be in for 40%, one might be in for whatever percentage. To get them to agree on that before they then even talk to the plaintiff.
Put an offer to the plaintiff.
But Martin, more often than not, you find that these defendants are at loggerheads and blaming each other. So
that's the difficult part of that mediation.
It can be
difficult cases to resolve.
Can be very frustrating.
It can be frustrating. It can be beneficial too, because you've got defendants blaming each other. So it's in their interest to try and resolve it.
Yeah.
But if there's cases in Victoria, I think, where there've been 5 or 6 or even 10 defendants, and one of them does not want to contribute, and I think a matter in the Supreme Court went to verdict
58 days on
the basis of one of the 10 defendants did not want to agree to contribute anything.
Yep.
And it was a sad case because it went for 58 days, as you said, in the Supreme Court.
Cost came to about $6 million, I think.
Yeah, that's changed again a little bit recently. The Supreme Court has run a pilot to where they have court managed with judges and associate judges playing the role of mediator to get involved in those complex matters like that. And
where
again,
there are multiple defendants.
Thank you, and try and sort out the problems.
Martin, I don't want to move us along, but offers in writing, Harry, tell us a bit about them. I mean, you've had your mediation or pre-trial?
Well, we're talking about alternate dispute resolution and settlements, but often what happens is that one of the parties goes away and puts an offer in writing, and under the rules of court, you have 14 days in which to accept or reject the offer.
There's implications, no doubt.
And then after that, what happens is there are cost penalties if you don't beat the offer. So,
well, what if you're not in court and you're trying to resolve it without the expense of going to issuing proceedings?
Well, there can be what's called call-to-bank offers. So call-to-bank offers are from a case in the UK. Mr. and Mrs. Calderbank had a family law dispute, and I think Mr. Calderbank put an offer, and the judge said, even though it was not in accordance with the rules, it had consequences for that matter. And to the credit of judges around the English-speaking world, and including Victoria, they've adopted the Calderbank principle.
So whoever lost had to pay both sets of costs.
There was cost penalties if you didn't beat the Calderbank offer. And the beauty of Calderbank is that it's flexible. It can be done at any stage. It can be done on the morning of a trial, halfway through a trial. It's a very flexible way of trying to resolve matters. So, you know, most matters, as Martin says, most matters resolved by negotiations at some point in time. Only 3% of matters go to verdict.
But sometimes they need that written offer.
They need a written offer, yeah. Before we conclude, we've got a very important segment called Tony's Mailbag.
This week's question, a lady named Daisy went shopping and she fell over in a supermarket. And her query to us is she was sent a letter by someone representing the supermarket that decided they're prepared to pay some of her medical expenses, but they want her to sign a deed before they pay this money over. She wants to know what is a deed and what's the effects of signing a deed. Marty, Harry?
Well, they've offered to pay medical treatment. So you think the insurer for the shopping centres is worried about the fall and worried about liability. However, they want to cap their responsibility or exposure and say, well, look, we're prepared to pay $1,000 or $5,000, but we're not prepared to pay any more. And here's a document for you to sign which says you finalise your legal rights. That is, that if you sign this document and in 2 or 3 or 4 years' time your condition gets worse and doesn't resolve and you need an operation, you can't claim against the supermarket.
So
it's
in
a barrier.
Circumstances, she should consult
a lawyer.
She should consult a lawyer, and signing a deed can finalise your legal rights, and in effect there's no remedy you've got, especially if the condition gets worse. I mean, you know,
she probably wouldn't have any medical reports outlining what her future complications might be. So
what her future medical costs are going to be. It's a once and for all settlement. Once that deed is signed, as Harry said, the matter is concluded. So she hasn't got any idea of how much the future expense is and what the treatment's going to be.
Harry, I think we're getting towards the end of the show again. So
we are. That's all we've got time for today. We'll be back next week with another show. Thanks for watching. As I say, we are passionate lawyers about personal injuries.
Thanks, viewers.
Thank you.
Thank you.